This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Marginalized musicians are upset with the DMCA and have sued YouTube Film at 11. This is the lawsuit in the United States District Court for the Northern District of California. So that's the San Francisco area, San Jose being in the San Francisco area. And this is Maria Schneider and Pirate Monitor Limited. And they are suing YouTube, Google, and Alphabet. So essentially that's just YouTube. If it's not fast enough for you, remember that YouTube has a speed function in the little gear thing down here in the bottom thing, and just choose a playback speed of a higher or lower speed. And YouTube does a really good job with it. This case is about copyright piracy. YouTube, the largest video sharing website in the world, is replete with videos infringing on the rights of copyright holders. YouTube has facilitated and induced this hotbed of copyright infringement through its development and implementation of a copyright enforcement system that protects only the most powerful copyright owners, such as major studios and record labels. Plaintiffs and the class are the ordinary creators of the copyrighted works. Ordinary creators? What? They are denied any meaningful opportunity to prevent YouTube's public display of works that infringe their copyrights. No matter how many times their works have previously been pirated on the platform, they are thus left behind by YouTube's copyright enforcement system and instead are provided no meaningful ability to police the extensive infringement of their copyrighted works. These limitations are deliberate and designed to maximize YouTube's and Google's and Alphabet's focused but reckless drive for user volume and advertising revenue. Moreover, the plaintiffs and the class are not only prevented from using any meaningful enforcement tool, but the system in place actually exacerbates the harms caused to them, including in a manner that bars defendants from the protections of any safe harbors under applicable copyright laws, such as the Digital Millennium Copyright Act. The copyright management tool that YouTube provides to the behemoths of the creative industry is ContentID, a digital fingerprint tool that compares videos being uploaded on YouTube to a catalog of copyrighted materials submitted by those entities permitted to utilize ContentID. ContentID is not only unavailable to plaintiffs and the class, but it actually insulates the vast majority of known and repeated infringers from YouTube's repeat infringer policy, thereby encouraging its users' continuing upload of infringing content. I can already sort of see where they're going here. You've seen the internet service provider, the ISP cases. I think Cox was one of them. There was another one, I forget the name. I think RCN got sued because they didn't implement a repeat infringer policy. Sometimes they had a repeat infringer policy, but they didn't implement it. You didn't actually get effectively permanently disconnected after so many infringements. So I think what they're going to try to do here is connect some dots to how much infringement is going on, or from how much infringement is going on to that case or those cases, and try to convince the court that YouTube is outside of its safe harbor because it's something. You'll see. Defendants reap billions of dollars from hosting videos, including millions of works that infringe. Defendants permit and facilitate infringement because it furthers their growth and revenue strategies, and because they have determined that plaintiffs and the class, unlike YouTube's preferred ContentID partners, lack the resources and leverage necessary to combat copyright infringement on a scale at which it is perpetuated on YouTube. Now, I'm going to go over at the end of this that there are alternative ways to look at this, that I think this is a bit reaching or a bit of a stretch. This isn't this way because of what they're saying, but this is a complaint. Remember, this is their complaint. YouTube has 2 billion users worldwide, 5 billion videos viewed every day. YouTube estimates more than 720,000 hours of video, more than 82 years worth are uploaded every day, equating to more than 500 hours of content uploaded every minute. However, to become the preferred platform for both uploaders and viewers, defendants knowingly permitted YouTube also to become a hotbed of piracy. From its start, YouTube recognized that its success was highly dependent on the rapid growth in online postings of user-generated content to be uploaded quickly with no pre-publication diligence, making the unauthorized upload of copyrighted material unavoidable. Google purchased YouTube with full knowledge of the rampant copyright piracy. Google chose to foster growth rather than protect copyright holders. Well, I mean, Google isn't the copyright holders, so what duty do they have to protect them other than what's designated in the law? In addition to the billions of dollars of direct advertising revenue, Google search and advertising independently gain value, capitalizing on the rapid upload of materials. For those entities with vast stores of copyright material and thus the leverage to require defendants to appease their copyright management concerns, YouTube created ContentID, which allows qualifying copyright owners automatically to identify and manage their content on YouTube. That's a little bit of a misstatement. ContentID does identify those, and then this is a second part to it though. YouTube then has policies in place, and it's these policies in place that they're complaining about. They're saying that major media creators get one version of ContentID that has all these features, but then Maria Schneider and her class don't get those features. And I'm assuming she's talking about the same level of features that Lawful Masses gets. It will show you, ContentID will show you where copyright infringement is and give you some ability to claim the video or message or start a dispute of some kind. But there's levels to this, and she's complaining that she and her class are not on the level with other major creators, that they don't get these other ContentID features. I'll get into why I think she's wrong about her lawsuit in a moment. Smaller rights holders are denied access to ContentID, or at least that version of it, and thus are relegated to vastly inferior and time-consuming manual means of trying to police their content and manage their copyrights. They must scan the entirety of YouTube postings, search for keywords, titles, and other potential identifiers. Plaintiffs and the class must then file individual takedown notices via YouTube or with YouTube via a web form. So she then compares these, it looks like. The following table contrasts the protections offered by ContentID with those accorded to, I guess, small-time or ordinary copyright enforcers. So ContentID screens at the moment of upload, she says, and others screen only after a video is uploaded. I'm not sure how true that is. I think they can't screen the content during the upload until after there's a complete file. Or maybe there's a way that they can scan as it's being uploaded faster for people who are bigger creators, major media and stuff. That doesn't seem illegal to me. Really, none of this seems illegal to me. We'll go over the various laws involved in a moment, but I don't see why any of this is illegal. Screening is performed automatically. That part, I believe, is true. On my information and belief, YouTube does offer more automatic ContentID features to larger creators. Now, I also don't know what's been put in place there. I speculate that those larger creators have in some way indemnified YouTube more than just the normal indemnification. Maybe the music industry has completely indemnified YouTube for not handling counter notifications. YouTube changed its policy for DMCA counter notifications. You get a takedown, you say, wait, you're wrong, I want you to have to take this to court. You can send a counter notification. Well, YouTube doesn't have to obey that, even though that's the way the law is written. So Maria Schneider, her ContentID screening must be performed through keyword searches. I think she's wrong there. I at 100,000 subscribers, have a version of ContentID that shows me where it found my material and then lets me decide whether it's infringing and what I want to do with it. But it does have to be done on an individual manual basis. She and I both probably still do need to manually find other content or other violating content that doesn't get flagged by ContentID automatically. And then, yes, there's something about being able to impose conditions or enforcement for major media, whereas others don't get the automatic enforcement. They have to either send takedowns or they have to make monetary claims using the interface one at a time and then wait for YouTube to act. So I get it. There's a disparity. There's no disputing that there is a disparity. The question is it illegal? We're going to move through this because this is getting long here. If a rights holder does not have the economic clout to qualify for ContentID, YouTube refuses to add their works to ContentID. Yes. Moreover, defendants have completely divorced ContentID from their repeat infringer policy. So she's saying that you must have a repeat infringer policy, as we discussed before, like the Cox case and the RCN case, etc. But that the ContentID claims do not create a copyright violation for the purposes of, incrementing the repeat infringements for a repeat infringer policy. So there's no consequence for uploading copyrighted content that then is claimed monetarily by ContentID as a monetary claim. The monetary claim just reroutes the advertising revenue to the claimant and away from the uploader. Mary Schneider is upset that ContentID doesn't also strike the account. I don't see why there's a need to do that. If she wants a strike, she can DMCA claim, which is not the same as a monetization claim. A DMCA takedown claim is for taking down, removing the material from the website. So Mary Schneider wants to eat her cake and still have it. She wants to have ingested her cake and enjoyed it while also still owning its value. She wants it both ways, and she can't have that. She can either issue a takedown notice or she can issue a monetary claim via ContentID. Why would you want both? Let's say Leonard French uploads Mary Schneider's song. No fair use, just a straight old upload. Mary Schneider comes along and wants both a ContentID monetization claim and an automatic DMCA takedown. On July 5th, Mary Schneider automatically issues a ContentID monetization claim, and YouTube automatically takes down my video. What was the point of the monetization claim? The video is now down. There is no money to be made. Mary Schneider, I don't think, has thought this through. So she's saying that YouTube does not give a copyright strike to ContentID claims. Google brags that 98% of its copyright issues are resolved via ContentID, but what it really means is that nearly all identified copyright infringing material is entirely insulated from its repeat infringer policy. This is not illegal. This is how they've decided to handle copyright infringement claims. If these authors or owners or major media companies or small media companies sent DMCA takedown notices, they would get the strikes. So why is she asking for both things? I don't know. Maybe somebody knows and will comment and tell me why I'm wrong. While defendants state that ContentID eligibility is based on a variety of criteria, only 5% of or less of people who apply for ContentID are approved. I'm not sure how she knows that. Plaintiffs have applied and been rejected. Okay, yeah. So at least we know that songwriter Mary Schneider is being treated the same way that Leonard French and Lawful Masses are. Defendants have forfeited their claim to DMCA safe harbor protections. Okay, that is a huge claim. Let's see how in the world they've done that. Rights holders who seek to actively enforce their copyrights by filing numerous takedown notices run the risk of losing access to YouTube's rudimentary tools. What? Rights holders who enforce their copyrights by filing numerous takedown notice run the risk of losing access?
I believe that's because there's only so many that they will process in a day. So I don't know the exact numbers. I don't think she ever says. But if there were, for example, 10 a day, and then you send 20, then you might have your ability to send DMCA takedowns restricted.
Okay, so they're saying that you only have the right to send so many. I don't know how true that is. Hear me out. There's a two-step process to this. If we're reading just the law, there's no such requirement in the law. In fact, YouTube has to obey DMCA takedowns if it receives them. So if it wants to stay, let's say that everybody's uploading a copy of the new Hamilton movie because it's exclusive to Disney Plus. Is that where it is? So let's say that everybody's uploading that. Can Disney send takedown notices more than 20? Well, of course they can. They've got that agreement with YouTube. Let's pretend that it's Mary Schneider's production. Can small-time creator Mary Schneider, pretending that she owns Hamilton, can she send more than 10 DMCA takedown notices? Yes. YouTube has to obey more than 10 takedown notices. Here's the distinction, though. You have an agreement with YouTube. Can you modify that number by agreement? Probably. You can probably agree that you can't bring a copyright claim against YouTube out of its safe harbor for a takedown notice past number 10 or something like that until YouTube and you agree otherwise. Disney gets that privilege. They can send as many as they want. Now, what if Mary Schneider didn't care about YouTube and she made Hamilton and doesn't care whether it's on whether she has a future relationship with YouTube? She can send as many as she wants. Doesn't matter because she has no relationship with YouTube. But she does. She does have a relationship with YouTube. She does have an agreement with YouTube. Maybe somewhere in that agreement is something about not sending more than 10. But that isn't a legal requirement. That's something between her and YouTube. It sounds like she doesn't like YouTube. If she didn't care to participate, if she didn't agree to YouTube's terms of service, I don't see any reason why there's a limit on DMCA takedowns that she can send. So that's what that misleading statement means, that they run the risk of losing access because they run out of a number of DMCAs they're allowed to send using the automated tools. I don't even know how true that is, but I'm going to take it at face value for right now. So they're saying that defendants are liable for the piracy because there isn't an opportunity to send a takedown notice. Again, I don't see how that actually works that way. Maybe that's the closest to a color of a legal claim that I've seen in this so far. They say the overall effect of defendants' inducement of copyright infringement, manipulation of search, willful blindness, data harvesting, and selective enforcement of copyright screening tools is to depress the value of creators' work and destroy the free marketplace for those works. I don't know, I would argue the opposite. YouTube didn't exist before the laws that allowed it to, so YouTube relying on those laws has made an economic a multi-billion-dollar business out of something new. I think Maria Schneider is just upset at the leveling of the playing field, and that major media gets favorable treatment because they bring in more money. That's just normal. That's just, I don't like it, but that's just normal. Like the fact that Leonard French can't just become a major media company because there are economic barriers to entry is not YouTube's fault. YouTube is part of the system, but it's not their fault. So Maria Schneider is a citizen of New York and a multiple Grammy award-winning composer and musician. She has exclusive copyrights to Hang Gliding, Greenpeace, and Journey Home. Pirate Monitor Ltd is a limited company in British Virgin Islands. So no, there's no tax dodging going on there. Pirate Monitor owns exclusive rights to reproduce, publicly perform the following works. Not even going to try.
They are Hungarian movies.
They're Hungarian movies. Okay. Copyright expressly gives Congress the power to promote the progress and science of useful arts by securing, for a limited time, to authors and inventors the exclusive right to their respective writings and discoveries. Copyright law encourages people to create original works and thereby ultimately serves the purpose of enriching the general public through access to creative works. The 1967 Act makes it illegal for people to publicly perform, etc. YouTube has user-generated content. Each of the copyright infringing acts has diminished the value of the works, the moral, legal, and economic rights. So they're trying to preserve multiple avenues there. And then she's going to go and repeat a lot of it. And so in an effort to keep this one fairly short, I'm going to start skipping a little bit. So basically what she's saying is that YouTube allows user-generated content. YouTube has a copyright compliance system, and that the copyright compliance system is specifically constructed to allow copyright infringement. Now, this argument has been made before. I don't have citations off the top of my head. Maybe I will by the time this video gets out. But this has been tried before, where lots of companies have said that YouTube doesn't do enough, and courts have said that YouTube does what it's supposed to. It does what it's supposed to under the law, and you're just upset with the law. So petition Congress to change the law. Don't sue YouTube to change the law that Congress made. Defendants' formula for success is simple. More videos, more viewers, more advertising. Sure. So then they're going to go on. I'm going to bet they're going to go on and say that YouTube turns a blind eye to copyright infringement.
There are a couple quotes in there of where she's going to make a claim that, 70 or 80% of what's on YouTube is copyright infringement, and that YouTube, when it was first bought by Google, Google had their own Google video service, and they pre-screened all of the videos before they went up, and they found that they couldn't compete with YouTube. So when they bought YouTube, instead of implementing their pre-screening tools that they had, they just said, okay, well, we'll assume everything is fine until we receive actual notice that there's infringement. And
so the argument's going to be that that's willful blindness, but that's not what the law requires. The law does not require that you check the copyrights of every single thing that you upload. In fact, quite the opposite. The law only requires you to take action when you become aware. So actual notice, red flag notice, so you have some huge warning, which is still some kind of active warning, not we previously sent a takedown notice. That's not red flag warning. That's what their argument's going to be here, though. We've sent so many takedown notices for this music that YouTube should know that every new upload is not allowed. But how would that play out? What if Mr. French came along and made a fair use? And then YouTube took it down automatically. I might have a claim against YouTube. YouTube might violate its DMCA safe harbor because it took it down without any knowledge, without doing that analysis. So it's actually the opposite of what Maria Schneider says. YouTube can't actively scan everything and do that analysis, or else we become like the live journal case where they now have actual knowledge. So it's actually not a violation for them not to scan everything for copyright infringement because there's no legal requirement to do so. And if they did scan everything for copyright infringement, that could actually put them outside of their safe harbor. Exactly the opposite of what Maria Schneider is saying here. And I think we're just going to end up having an opinion where a court explains all this to Maria Schneider. This is what it's going to be. It's just going to be a court just explaining to Maria Schneider why she's wrong. But it's not going to happen until YouTube makes a motion to dismiss. So they're upset at the removal times for videos, but that's written into the DMCA. If YouTube has been violating the DMCA, yeah, that could be something, but I don't see that here. Her argument boils down to this. Copyright holders should not be forced to repeatedly demand that the same platform take down infringing uses of the same copyrighted work while other rights holders are provided access to a standard digital fingerprinting and blocking tool. By not allowing plaintiffs to block the uploaded infringing materials at the time of upload, defendants force plaintiffs and the class into a time-consuming, cumbersome, inaccurate, and flawed manual process to enforce their copyrights, all to the benefit of defendants' money-making machine. The inequities of this two-tiered system ensure that at best, unauthorized YouTube uploads will always outpace the ability of plaintiffs and the class to take those videos down. No, I don't think you can go so far. That last sentence, that these inequities always outpace the ability. I think that it's true that they do very often outpace the ability of plaintiffs, but that is an operation of the law, not an operation of YouTube's policies in particular. So YouTube is obeying the law. So then they also go into copyright management information. Okay, so this is like the attribution, the author and watermark and stuff?
Yeah, so what she's going to claim is that when someone downloads an MP3 from an authorized place, that MP3 file is going to have metadata attached to it that identifies who the author is. But when you upload to YouTube, YouTube removes that metadata rather than saving it, and it makes it harder for small artists to find the infringing works. Yeah. Because that data has been removed.
Except that we recently dealt with a case that involved 1202, and that's not what 1202 is. It says this: no person shall knowingly and with intent to induce, enable, facilitate, or conceal infringement to provide copyright management information that is false. That's a super high bar. They're going to have testimony and evidence that shows that YouTube intended to induce, enable, facilitate, or conceal infringement by knowingly and with intent providing false copyright management information. I don't think they're going to be able to meet that super high standard. They also say in here, no removing or alteration of copyright management information. Again, intentionally then distribute copies that have been removed. So I don't think they're going to meet that definition. The place where the copyright management information has to be is the title or identifying information about the work. This would have to be something where the uploader put the copyright management information into it, and then YouTube gave it a different, gave it a different author. Like, let's say Lawful Masses with Leonard French uploads a video, and then YouTube makes it a, uncivil law video. That would be a violation of copyright management information. If Leonard French uploads a Lawful Masses video, and then Leonard French removes the author information from the video, that's not YouTube's problem. Maybe she's talking about something else here. I don't understand. If she's talking about the embedded metadata in the digital file, that's not what I think. I don't think that's what they're talking about in the law. Thus, despite having clear knowledge of the presence of copyright management information and the vital role, defendants have created a system that not only disregards, but eliminates or conceals. Okay, and then intent. Where did you see the word intent in there at all? Defendants are aware that their display and distribution of plaintiff's works with missing, incomplete, or inaccurate CMI has induced. Yeah, but it's not defendants that have removed or, it's not defendants who did that. It's the uploaders. Then they go and say that they're not entitled to their safe harbors because their limitations are arbitrary. That as long as they obey the law, their limitations can be arbitrary. You're allowed, they have an agreement with you and they're allowed to obey the agreement and they're allowed to obey the law. Okay, so they're back to the repeat infringer policy that ContentID is not an infringement policy violation, so therefore it's not a repeat infringement policy, checkbox or increment, and so you don't get 3 strikes for 3 ContentID claims.
And I think it's important that you don't get 3 strikes for ContentID claims because ContentID can't do a fair use analysis.
Right. And it's a choice. You're allowed to do a ContentID claim because you want your video up on YouTube to be displayed by these other channels. You just want the money from it. So that's actually a really great compromise. YouTube must establish that it has neither actual nor constructive knowledge of infringement. No, quite the opposite. You're the plaintiff. You have to establish that YouTube has actual or constructive knowledge, not the opposite. What lawyer filed this? Jeez. YouTube must, in order to qualify for protection, establish that it does not financially benefit. No, you have to establish that it financially benefits in a violating way from the infringements. So it's not just the fact that it benefits, it has to knowingly benefit from the infringements. So it's a much higher standard than they're letting on right now. And the judge is going to notice that. So they're saying that because YouTube could do more, that to not do more is a violation. We still have 15 pages to go, so I'm going to start skipping really fast. So that's the CMI, and then here's the class action. Who are the people? The class is all persons holding an exclusive right to a copyright after 1977 whose works have been uploaded to YouTube within a statute of limitations, entirety or in part, where such person has had to submit a successful takedown notice, where such person's work has subsequently been infringed. That doesn't say anything about fair use. There is zero acknowledgement of fair use in there. All persons holding the exclusive right to publicly perform, published after 1976. Oh, the first one was for works first going into the public domain after 1977. Okay, but that would also usually include this. I don't know why there's 2 separate class definitions there. Excluded from the first class are United States works not registered, and any person who has authorized YouTube to display their works. So they think there's a lot of people. The claims are typical. These are part of the class action elements. And they want to know, claim-wise, about direct infringement of copyright, contributory infringement of copyright, vicarious infringement of copyright, willful copyright infringement, precautions or mitigation of damages, the repeat infringer policy, whether they have actual or constructive knowledge, whether technology exists to identify and remove copyrighted material. There's nothing in the law about that, but okay, they want that to be a legal claim. Whether defendants' refusal to extend the use of ContentID to all copyright holders permits defendants to earn more revenue. Whether defendants restrict the number of takedown notifications that a class can submit, and whether they did that illegally. The percentage of revenue earned by YouTube. These are things I'm not sure they're going to be able to have a court find, as in judgment. Whether defendants have knowledge about the copyright management information, whether defendants distribute or publicly perform works, knowing that copyright management information has been removed. And so, direct copyright infringement is going to be the simple one. Is YouTube guilty of directly infringing copyright? Did YouTube make copies in violation of the law or display in violation of the law? I don't think so. I think the Safe Harbor protects them. I think the Communications Decency Act, Section 230, protects them as well. Inducement of copyright infringement means when you contribute. So I'm not sure what inducement is different from contributory. Let's see what they have to say. Defendants control or influence which videos users upload. So I guess inducement would be like asking someone to upload a copyrighted video, similar to contributory, which was what I think it's the same claim. But contributory copyright infringement is when you induce somebody to commit copyright infringement, when you knowingly support their activities.
I believe there was also a claim in there that because YouTube has an algorithm that recommends videos, that YouTube actively promotes videos that are copyright infringement.
Okay.
Does that sound like a strong argument to you?
Doesn't sound like a strong argument to me. It's an argument. YouTube can then make its arguments in reverse about how its Content ID system works. And I'm not entirely sure when exactly it becomes copyright infringement. If someone uploads, let's go back to Hamilton. If someone uploads an unauthorized copy of Hamilton and YouTube puts that into the recommended videos or trending page or whatever, the infringing copy, is YouTube then infringing as well? Maybe that's a LiveJournal case where they've now moderated it. I guess it depends on how hands-on it is. Because it was hands-on with LiveJournal, then LiveJournal was liable for copyright. If YouTube has done it in a hands-off way that doesn't seem to account for copyright in a positive way, like in other words, doesn't seem to trend videos just because they're copyright infringement, then I don't think they're committing that sort of inducement or contributory copyright infringement because they're not the ones promoting it because it's copyright infringement. Then they have something called vicarious copyright infringement in here. That's respondeat superior. That's, I work for somebody, therefore my employer is responsible for my copyright infringement if I commit copyright infringement within the scope of my job. So let's say I'm a delivery driver and I have a car accident in my delivery truck while I'm on duty and while I'm making deliveries and stuff. Likely my employer is liable for my car accident, if they're liable. If anybody's liable on my side, then it's going to be my employer. So they say defendants are vicariously liable for the acts of their users because they have the ability to supervise users. That's not how the DMCA works. That's not how CDA 230 works. They go into the copyright management information that in the process of uploading the digital file of plaintiffs and classes, musical or audiovisual work, for unlawful and unauthorized copying, display, and distribution, defendants intentionally remove or cause to be removed plaintiffs and classes' copyright management information. I don't understand how that's a claim. So they're saying that if Leonard French uploads a video to YouTube that contained metadata that says this is really owned by Maria Schneider, that YouTube disregarded that. But that copyright management information doesn't tell YouTube anything about whether it's a fair use or whether the information is correct or not. What the copyright management information law says is if YouTube intentionally removes copyright management information for the purpose of facilitating infringement. I don't think it's doing. And they want a class action. They want an injunction that stops YouTube from infringing. They want to adopt Content ID for everyone. They want to disgorge all profits and monetary damages from everybody. They want to award prejudgment interest, attorney's fees, and all other relief. I personally think this lawsuit is ridiculous. I can understand wanting to make a point by filing a lawsuit like this. The fact that there are two law firms and 4 lawyers involved in this baffles me, because I don't think this has a chance in heck. This doesn't have a snowball's chance in heck. That YouTube has the right by 2 ways. 3. They have CDA 230, which prevents YouTube from being liable for the user-generated content that's uploaded by its users. They have DMCA 512, which prevents them from being liable for content that is infringing as long as they obey infringement notices of a particular format. And those infringement notices have to identify one copy at a time. You can send multiple infringement notices, and sometimes you can even send an infringement notice for multiple different copies of the same thing, like multiple links for different links for the same item. But you still have to send individual takedown notices for each work of authorship. So yes, do hundreds of thousands of DMCA takedowns get sent every day? Probably. It might be hundreds of thousands a month, maybe not hundreds of thousands a day, but it could be. And yeah, that's normal. What's this thing about YouTube limiting DMCA takedown notices? I don't get that. I don't see why YouTube would have any reason to limit DMCA takedown notices. Maybe it's something they've done by agreement with small creators. I haven't sent multiple DMCA takedown notices, so I couldn't tell you if there's a limit. Somebody can maybe comment on what their experience is with that in the comments below. But I think that's a ridiculous lawsuit. I don't think it's going anywhere other than going to teach us why Maria Schneider and her class are wrong. But YouTube will have to file a motion to dismiss once they are served with a lawsuit. And we should see that. We'll cover it. And it should be interesting. If somehow Maria Schneider gains some ground, that would be like remarkable and breaking and precedential and everything. So we'll see what happens. LBX Annie, is the fact that YouTube requires you to meet the requirements to be partner to use ContentID illegal or worthy of a lawsuit? No, I don't think that YouTube has any requirement to give you privileges. Like, YouTube can set up its own business how it wants. And as long as it obeys the minimum requirements of law, it can then add value onto those with features for larger creators. You bring more money to the platform, you get more features. That's just economics. That's just business. I open up a store selling you widgets. I buy my widgets, in bulk from the widget company at 100,000 widgets at a time for $1 a piece, but then I sell them to you for $10 a piece. Do you have a claim for the $9 difference? No, I just set up a business identifying the economic difference. I can buy them in bulk and sell them to you for a 90% markup. That's just business. I don't get to you don't get to sue me. You don't get to sue me. You don't get to sue me successfully. You don't get to sue me successfully just because you don't like the fact that I made money. That's business. That's economics. You're allowed to make money. YouTube is allowed to offer more features to its more prominent creators. These plaintiffs are just upset that they aren't those major creators yet. And I hope she becomes one and gets all the features that she wants. Also, I seem to recall YouTube having a policy of kicking people off the platform, DJ Shorty Hot Forever, if they sue YouTube. So now Maria Schneider has risked her ability to ever have herself directly on YouTube, or maybe this pirate company, because YouTube seems to ban people from their platform when they sue YouTube. Another reason why Lawful Masses hasn't sued YouTube, besides having fairly weak legal claims other than just being frustrated, is that, we don't think that it's a great idea to poop where you eat. Let's put it that way. Let me know what you think in the comments below. That's our show, everybody. I'm Leonard French, your favorite copyright attorney. Lawful Masses is a community-supported legal education and legal news channel. Thank you very much for your support on patreon.com/ljfrench and sponsus.com/law, and YouTube memberships and Floatplane memberships and Twitch subscriptions. Special thanks in the month of July to BU1 Simmons. And thank you to the July $50 plus supporters: Nicely Done Defense, Joe Tyson, West Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Girls in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory, Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandyn Abel. And thank you to the July $5 plus supporters. Everybody's scrolling on the LED panel and will be on the crawls in the videos that drop. I love you all. Have a good week. I'll see you soon.